House Bill 734.
As called, we are moving with House Bill 734. Mr. Gonzalez, please read the bill.
Thank you, Madam Vice Chair. Members, this is House Bill 734 by Representative Villio. It provides relative to victim notification.
Madam Chair.
Thank you so much, Madam Vice Chair. Members, I have with me here today the Executive Director of Louisiana Sheriff's Association, Mike Renatson, and Ms. Tracy Barbera with District Attorney Hillamore's office. And I appreciate the opportunity to bring this bill, HB 734, on behalf of the Sheriff's Association. In last year's attempt by some to have clemency granted to the 50-plus death row inmates, the defense team reached out to victims' family members. They reached out by a letter which I believe was misleading to many and promoted an intermediary, a victim counselor, so to speak, to facilitate communications and dialogue between the victims' families and defense team in an effort to sway their upcoming testimony before the Board of Pardons and Committee on Parole. This bill is brought on behalf of the Sheriff's Association and those families as a direct result of those actions which revisited trauma upon trauma on these families. The proposed legislation provides for victim family rights in capital cases. It provides that they shall have the right not to be contacted by the offender, any family member or friend of the offender, any legal representative of the offender, any person or group representing the offender, and they add a violation of those rights to the obstruction of justice statute. And I'd welcome questions by anyone and certainly comments by Mr. Renatza and Ms. Barbera. Thank you.
Thank you. It looks like we've got two amendments, two sets of amendments. Mr. Gonzalez, please review those.
Thank you, Madam Vice Chair. This first set of amendments is set 1377, and what it does is it specifies on page 2, line 25, as well as page 3, line 7, that any appointment made by certain individuals who seek to contact the victim's family has to be requested, approved, and arranged through a victim service coordinator appointed by the prosecuting agency in the victim's family. And that's what this does in its totality.
Thank you, Mr. Gonzalez.
I would offer that amendment.
The amendment has been offered. Any objections? Seeing none. We have the next one.
Thank you, Madam Vice Chair. Members, this is Amendment Set 2343, and it's just changing references of the term defendant to offender just for consistency and uniformity purposes within the bill.
I'd offer that amendment as well.
Amendment has been offered. Any objections? Seeing none.
Thank you.
Rep. Knox.
Thank you, Madam Acting Chair. Madam Chair, I have a question just for clarity. Is the bill pertaining only to those who are on death row, or is it all offenders?
This particular legislation has to do with adding a subsection to Title 40, I believe, relative to capital cases specifically. And so it would pertain to capital cases. It adds, I'm sorry, Title 46. It adds 46-1844 subsection Y, and it regards contacting a family member of a victim in a manner that knowingly and intentionally violates that provision. And the subsection Y that is being proposed is specifically relative to capital cases.
Thank you for that. And the scenario, will the inmate have notice that they are not to contact family members?
And I'll let Ms. Barbera and Mr. Renata take that question to the extent they wish, but it does require the victim to actually complete a form. But if either one of them want to go ahead and take that question.
Madam Vice Chair, members of the Criminal Justice Committee, Michael Renata, Executive Director, Louisiana Sheriff's Association. First, I'd like to give you a little background on the bill and what brought about our desire to protect these individuals. If you've lost a loved one, if you've lost a loved one to murder, then you may understand what these individuals have gone through. For those of us, and I look at Sheriff Wiley, I look at former Chief Deputy Tony Bacala, former Deputy Sheriff Fontenot, those of us who have delivered death messages to victims of family members who have had a loved one murdered, you think you understand what that individual has gone through, but I can assure you, you have just witnessed the worst day of their lives, a day that never goes away, which starts a roller coaster of emotions, and that is perhaps the lowest ebb that ever will be. It continues for that family of ups and downs from the point of arrest, and in which there is some resolve on their part, knowing that justice may be accomplished, that that individual is now behind bars. But then you have to put yourselves in that family's perspective. Try to, is what I put myself through before we went with this instrument. What it feels like to have to attend court, to look at pictures, to listen to autopsy reports, and to listen to forensic evidence about their loved one. And these are very gruesome details, and that's, again, another low. So at the end of that trial, assuming that the outcome results in a conviction, then that's really another high point in their lives, which quickly changes with the many appeals that ensue in a case involving a capital case where a death penalty has been imposed. There will be many opportunities for these individuals to have to appear in court. It may be as many as 20 times, it may be more. But that roller coaster is a tremendous effect on their lives, which seems to never go away. So what I am saying in finality is that knowing what these victims went through repeatedly was culminated this past summer with an effort that was unfettered by individuals attempting to contact them for the purpose of securing what we consider to be just a letter to allow to ask them
Mr. Renata?
to request clemency.
Time is up, sir.
I'll
I let
stop
you
at that.
finish the sentence. Mr. Knox, your time is up as well. It's 3 minutes. Thank you, sir. Any more questions from committee members? Seeing none. Yes, you have a question for another? Yes.
Good morning. I'm Tracy Barbera. I'm First Assistant District Attorney for Hiller Moore. And Representative Knox, all the offenders are not allowed to contact their victims. And I handle the majority of the probation or the pardon and parole hearings for our office. And oftentimes that is one of the things that the victims say is, well, I never heard from the individual who did this to me. He never apologized. And the board has to explain to the victims at that time, or sometimes I have to in preparation for the hearings, that the offender is prohibited from doing that. So this extends, as you saw in the bill, to additional people who are acting on the offender's behalf or I'll just be frank with you, trying to disguise the fact that they're acting on the offender's behalf. Victims are all different. One of our first-degree murders here in East Baton Rouge Parish, Mr. and Mrs. Wayne Guzzardo, have testified before this committee before. They are very active. They never missed a hearing, never missed a thing concerning Stephanie and her other victims' homicides. In the capital cases that we referred to, in the clemency hearings that occurred late last year, we had some.
Excuse me, can you come closer to the mic?
Oh, I'm so sorry. We had some different reactions from victims. I'll read to you very briefly what one young lady wrote. She was a teenager when her father was killed, and she said, "I have moved on with my life. I am raising my kids to learn good from bad, respect life in all forms. It is time for his consequence to be upheld. I want to never hear his name again. Please remove me from all further contact regarding this individual. He has taken enough from my life, and I shouldn't have to offer him any additional time nor space in my mind." So you do have different extremes from these individuals. This particular lady who wrote this letter to the board, she found out about this because someone appeared in her driveway and told her that the murderer, his case had been reopened. That's how she found out about this, not from the district attorney or the assistant district attorney or a representative from DOC. This contact was made before the clemency application was even filed. And so that is our concern here. Your case has been reopened, and that happened so long ago. I've been with our office for 34 years. Because of that, I have prosecuted cases that have resulted in life sentences, 2 death row cases. When changes happened in the case, when there was a reversal or something was going on, I was the one that was able to call these people. These older cases, they're getting calls from strangers. They don't know what's going on. They are reliving this horror. These letters that came in the mail to them, Warwick Dunn, his sister up in Atlanta, children of Betty Smothers, they've maintained a relationship with Hiller over the years. I think Warwick also testified before this committee. They just all of a sudden get a letter saying, "Hey, we want to talk to you. We don't represent the defendant, but we want to talk to you about his case." So this is a troop to protect the victims. Don't continue to traumatize them.
And thank you for that. And that's what I wanted to get clarity on. Thank you to Sheriff for giving that clarity. I have lost 2 family members, and I certainly wouldn't want to be contacted by the individual who killed or murdered them. I just wanted to make sure that they know I don't want to hear from them. And so from what I'm understanding, that's what this legislation would do.
Yes.
And give me the right to have some kind of response to that as well. Is that correct?
Yes, sir.
Thank you for that clarity.
And further, Representative Knox, if you listen to the amendment that I have requested, it did, because there are some individuals who want to reach out to the offender or the offender's family, and that's why the statute already provides some language relative to being arranged through a victim service coordinator, which we have those individuals that work for our DAs, and so that amendment does allow the language as it is currently, or prior to the amendment, just said request, and I didn't want anybody to think, well, you can request it and therefore that satisfies it. No, the request has to be made through the victims coordinator. It has to be arranged through the victims coordinator. It has to be coordinated by the victims coordinator, and so that's what that amendment does for those individuals, those victims' families who want that.
Representative Fontenot.
Thank you, Madam Vice Chair. I just appreciate you bringing this. And, I think in the last year or so, I had a hearing on a homicide, and the victim's family showed up with all these letters from the perpetrator who killed their father. And, but nevertheless, I wanted to yield my time to Mr. Renatza. I think you were making a valid point that deserves to be heard.
Thank you very much. This has to do, with the concerted effort on our part, on the District Attorneys Association as well. We thank them for their support in helping to draft the measure. It really is about a process, and that process is designed to protect the victim. The victims were absent in most of the discussions this past summer. There was never much discussion, again, pertaining to the victims of those 58 cases. So we wanted to shift that and level the playing field for these individuals, not to deny justice in any way for people who are trying their due process, but to allow protections for these victims.
We
Thank you
appreciate
very
it.
much.
Thank you. That's all I have, Madam Vice Chair.
Thank you. The board is clear. We have green cards in support. It's not lit up, so, no, hold on. Rep. Wiley.
No, I just wanted briefly reiterate what Mr. Renatza said in the panel here about the series of experiences, all of them horrific, that happened with families and survivors, and for the ultimate insult and the ultimate invasion of their mind. Here's a lady writing you and saying, I don't even have room in my mind anymore for this individual. And for certain individuals, and this has to be said, the impetus for this was an elected official who began this, all right? The elephant in the room, it was the governor who ordered this, okay, the former, let it be said loudly. And for them to invade them, it's just absolutely an insult to good people everywhere. Thank you.
Thank you, Rep. Wiley. We have green cards. Present and in support but do not wish to speak, Darren Alleman, Jefferson Parish DA's office. Billy Joe Harrington, I'm president and in support and do not wish to speak. President, District Attorney, President of the LDAA. Present and in support but do not wish to speak, Otha Curtis Nelson, Jr., Deputy Director, Louisiana District Attorneys Association. Present and in support but do not wish to speak, Gary Bennett, Assistant Director, Louisiana Sheriff's Association. Present and would like to speak, you are speaking, Michael Renatza, Executive Director, Louisiana Sheriff's Association, and a green card for Tracy, present, and she has spoken. Those are the green cards. We have some red cards. Present and in opposition but do not wish to speak, O'Neill is the last name. Present and in opposition but do not wish to speak, Tammy Jones, a vote. Present and in opposition but do not wish to speak, Bruce Riley, a vote. Present and in opposition but do not wish to speak, Terry Landry. Jacqueline Lindwin German is present and in opposition and do not wish to speak. Sarah Whittington, present and in opposition but do not wish to speak for all those cards. The other red cards are present and wish to speak. Samantha Kennedy. Present and wish to speak. Denny LaBeouf. Present and would like to speak. Allison McCrary. If you each will take your seat and prior to your speaking, make an appearance, tell us who you are and who you represent.
Would it be okay if Denny LaBeouf went before me?
Absolutely.
Good morning, and thank you. My name is Denise LaBeouf. I'm a longtime capital defense attorney in Louisiana. I took my first case 35 years ago in this state. This bill may actually harm victim family members, and I have lots to say about some of the comments by the proponents, but I'm going to let the others speak about that a little bit. I merely want to address the legal problems with the bill. This bill, if passed, is unconstitutional on several grounds and will have the immediate effect of either halting or delaying capital cases at all stages. Its First Amendment problems start with it is perspective-based speech prohibition. It prohibits. It's a restraint on speech based on the opinion or perspective of the speaker. That is presumptively unconstitutional in First Amendment law and requires that the bill defeat the strict scrutiny. It can't. It's also void for vagueness. So we don't have anything in the law called the clemency process begins. As a capital defender, I'm seeking clemency from the moment I meet my client, from the moment I start the case. And I have an obligation to do that under the Louisiana Public Defender performance standards and under the ABA guidelines. If you fix that, which you can by saying if an application is filed, it still doesn't remove the fact that there's always concurrent litigation. I've never had a case that went to clemency where we weren't also in the courts in successor habeas or habeas counsel efforts. So this prohibits a lawyer in an active case speaking to the victim's family members. It's also void because contact is vague. Does it mean I can't call back somebody who's called me if they left a message? Does it mean if she walks up to me in the parking lot and says, I know who you are, I'd like to talk to you, can I not contact her in that way? There's an 8th Amendment, 14th Amendment obligation, which can be addressed looking at the realities of capital cases. Many of them are intra-family. The victim's family members are fact witnesses. They're mitigation witnesses. They can speak to the self-defense. They can speak to alternative suspects. In small communities, particularly true. Neither side controls access to the truth. Witnesses have the truth. You can't put a gateway up to stop people from asking for the truth. The 6th Amendment problem is the most significant one for cases. That duty to investigate requires.
Thank you. Your time is up.
Okay.
Rep. Knox has a question for this witness.
Yes.
Yes.
Thank you, Madam Acting Chair. It's Ms. LaBeouf.
Yes, it is. Thank you.
I'm not a lawyer, and I appreciate you being here, bringing that perspective and clarity to this legislation. What I'm trying to understand from your legal standpoint and my simple understanding is just on the basis alone, if my loved one is killed by someone who is in prison and I don't want them to contact me, I don't want to be bothered. I don't want to be traumatized. I don't want to hear from them. I don't want to hear from anyone that's even related to them. What I'm trying to understand is, what is it that you're trying to get me to understand if I'm the victim? Just on a simple premise, I don't want to be contacted.
You absolutely have that right, and you have that right now. You don't need this bill to have that right.
What is it in this bill that's not making it that way anymore, I guess is what I'm trying to understand.
The criminalization of a lawyer or a legal team member seeking to understand that. If I try to access a victim's family member with a respectful letter or an approach of that sort through me or a legal team member, the minute they say, I don't care to hear from you, that's it, we're done. I mean, and that there would be nothing else. If I continued to...
Is that the case now? That's what I'm trying to
Absolutely,
understand.
that's always been the case. It's in my practice and everyone else's. But this bill, by criminalizing it, sets up a conflict where I have to turn to my client and say, I now have a conflict of interest with you because I don't want to go to jail. I don't want to send my investigator into a situation where she could go to jail. So I have a conflict with you. I got to ask the court now, appoint me a conflict counsel, capitally qualified, to advise this guy because I'm not sure I can be his lawyer. And that is a situation which takes a lot of litigation and nobody wants. But the right of, one thing I really agree with that one of the previous speakers said is every victim is different. Every victim family member is different. And we don't want to set up two tiers here. The good family members who agree with us and the bad family members or second-rate ones that don't agree with us. We just want to listen and learn.
And as I wrap up before my time runs out, again, I'm not a lawyer, and I'm trying to appreciate your wisdom. And it's if a family member is a witness, isn't there another way that you can compel or subpoena them to come and be a witness rather than contacting them via letter or however other means when they have indicated they don't want to be bothered with anyone associated with the person that killed their loved one?
Well, if I started with a letter,
You may complete.
can answer the question.
Yes.
If I started with a letter or some outreach, the person says, I really don't want to be contacted, but in the situation of a woman kills her abusive spouse and a family member is a witness to the prior abuse, very relevant, a fact witness, I need to talk to them. Of course I can subpoena them, but that's not the way that you want to talk to witnesses. But, and that wouldn't, this bill wouldn't stop that at any rate, and wouldn't change that. But I mean, the way that you always want to talk to a witness is to say, do you have time? I'd like to talk to you. If they say no, I mean, it's bad practice and bad law there are laws against harassment already. They're out there.
Madam Chair.
Thank you, Madam Vice Chair. Ms. LaBeouf, perhaps an answer to Representative Knox's question, and maybe you failed to read it. Let me establish this. You just agreed that if you would reach out to an individual, a victim's family member, and they'd say, I don't want to be contacted, that you would respect that, correct?
Yes, I would.
So perhaps you would want to read page 3 of the proposed legislation, and that would be lines 12 through 13, that say the prosecuting agency shall provide notice of the document by United States mail to each party in the case. That notice being the form filled out by the victim's family members that says, I don't want to be contacted. So I would suggest that we have satisfied what you just said by providing that notice. And I just wanted to let, since you didn't indicate that to Representative Knox, I wanted to point that out to you in the legislation. Thank you.
Thank you, Madam Chair. Rep. Walters.
Thank you, Madam Vice Chair. Quick question of clarity. How can an attorney properly try a case fairly if this bill criminalizes attorneys?
I think there's a real conflict, and that is the conflict that I would explain to my client. So if I have a client and I feel that I could go to jail for doing my job, for doing something that in black and white is in the performance standards required of capital lawyers in this state, I say to him or her, I'm sorry, but I can't tell you that I'm doing everything I should on your behalf if I'm afraid of going to jail. I'm going to ask the judge to appoint capitally qualified conflict counsel to advise you where we go from here. But the next lawyer is going to have the same problem.
Okay, and second question, the Sixth Amendment that you were talking about earlier, you didn't get to finish your statement on that. Could you speak a little bit more on that, please?
Thank you. Simply that the Sixth Amendment, the primary obligation of capital counsel is to investigate the case. Most of the cases where the death penalty is reversed, most of them for years, have been for failure to fully investigate. And it is an explicit, and it's been the case since 1932, Powell versus Alabama. A thoroughgoing investigation is a must. And in that case, investigating the victim was very much a part of the case because it was a capital rape case. It's the Scottsboro Boys case.
Thank you.
Thank you. Ms. Kennedy?
Hi, thank you. My name is Samantha Kennedy with the Promise of Justice Initiative. I'm here today to read into the record testimony, not of my own, but I'll just provide a little framing, which is what this testimony from Richard Burr, who's a national expert on defense victim outreach and was one of the co-founders of the initiative. The purpose of this testimony is to shine light on a very specific and limited understanding of what victims' family members need or want. Prosecutors are not the sole protectorate of people who've been harmed by violence. So now reading into the testimony, or reading into the record his testimony. With the defense of Timothy McVeigh in Oklahoma City bombing case from 1995 to 1997, a new form of practice emerged in defense of capital cases, defense victim outreach, or DEVO. The defense team in the McVeigh case felt that we had to make some sort of a form of outreach because the devastation was too overwhelming not to do something that might be helpful to victim family members and survivors while still fulfilling our duty to represent. Mr. McVeigh to represent Mr. McVeigh zealously. To do this, we've developed a method of outreach utilizing the principles of restorative justice and under the guidance of Professor Howard Zehr of Eastern Mennonite University. At the core of our method was unconditional respect for the survivors an open-handed offer to address the devastating harm stemmed from the crime. Since 1997, DEVO has become a standard practice undertaken by defense teams in capital cases nationwide. DEVO recognizes a historical gap in communication between victims and defense teams and represents a more holistic approach to criminal justice process by recognizing and honoring those who have been harmed and working to meet their needs in whatever ways might be possible. The goal of DEVO is to offer a safe and respectful avenue for family members and survivors to communicate with defense teams, should they choose to do so. The discussions might evolve is guided solely by each person. Some want to express their concerns, beliefs, frustrations, and anger directly to the defense team. Others have questions that can only be answered by defense attorneys or the defendant, because often they are the only people in the position to provide meaningful information about what happened and why. There are many other possibilities, and the focus of outreach is to learn about each person's needs and concerns and to discern ways the defense team might be able to offer information, assistance, or greater understanding through the legal proceedings. Despite the adversarial nature of criminal justice system, many survivors of capital murder have taken up the offer of defense teams to provide information that meets their needs and interests. Though the practice has evolved.
Thank you. I'm going to remind the witnesses, please watch those dots. When it gets to yellow, start wrapping up, because red, in accordance with our rules, means you need to stop. But I do have a question. And it goes back, I think we've had this before, but it needs to be said. We talk about recognition and honoring. This bill does recognize and honor the victims' rights to not be bothered. I mean, that's as plain English as you can get. So I don't know. Or maybe you can expound on the language with DEVO and how this impacts restorative justice. If I tell you, like Rep. Knox said, that I don't want to be bothered, I don't want to have these conversations, and I can do that at the outset. So you never need to contact me, because I'm going to tell the victim coordinator and the victim advocates that are in these offices that I don't want to be contacted. Mm-hmm. What's the problem with that?
So there's no problem with people asserting that they don't want to be contacted. But what happens is, at the conclusion of a trial, which is obviously is emotional and traumatic and is horrible, you're asked to sign a form. 20 years later, you will not know. You've signed some form. None of us remember some form we filled out 20 years ago. What will happen is you will not know what you don't know. You will not know that you could be that someone could be actually answering your questions. Someone could be, you're in a different stage of your life, which is actually what many victim family members. There are victim family members that we know and who have testified in this space that are going to go to their grave feeling the same way, and they have every right to. But there are people who are on evolution and don't know that they don't have access to information that they want because it's being barred from them. And so what this does is it criminalizes the outreach that could be happening to those people, which they can elect to say, to saying that they don't want. But this form that happens, that's just like set in time, that can't be changed, it's set in time forevermore, unless someone should remember that it exists. I suppose they can opt out of it or something later. But the point is this prevents that communication in a very fictional space, in a space that happens in the most horrible time in someone's life that they're being held to. And the fact of the matter is it's limiting and restricting information and opportunity. And what we know from victims is that they change their minds over time.
And they have the not to interrupt.
Yeah.
They have the right to change their mind.
Absolutely.
And I can promise you that if you've ever been a victim,
as I have,
that 20 years is not enough time. You remember saying, I don't want to be bothered. And if you change your mind, you still have the right to do that. No one is saying you can't change your mind. And I apologize, Madam Chair, because it was just to get to the bill. Rep. Wiley.
Yes, thank you. Mm-hmm. I'm curious, we talk about a letter, a
Yes.
nice, well-written letter, and conforming to the guidelines that you explained to us. What happens when the letter comes back unopened? You couldn't find that person, or the letter did not get to them. What would be your next course of action?
So the letter's not delivered? That's what you're saying?
Not get to the intended person, a victim, family member, whatever the case. If you don't get the letter to them, what happens then? What are your next course of action typically?
So I want to be so this letter is focused on Devo, but we should understand that other people that are in this, that would be impacted by this bill, are spiritual advisors, as we said, defense team. So I think that the course of action would be different depending on where you sit in this.
All right. First of all, I think it's intrusive, just a personal opinion, and it's clear how I feel about this. However, the letter itself seems clinical and benign and et cetera. Are you in favor of any time an extension of the defense meeting, of going to a person's house, a victim's home, a victim's work, finding them on a street corner, standing by the mailbox, and when they come out? Are you in favor of that?
I think that, no, I'm not in favor of finding people on the street. I think that's a mischaracterization of the intention.
At their home?
I don't know that happens.
Are you in favor of it? Would you reject that practice?
I don't know.
All right, thank you.
Rep. Walters.
Thank you, Madam Vice Chair. Can you clarify spiritual advisors? Does this include people's pastors?
Yes, it would. It would if they reached out to, if they were counseling family members and also were working with the person on death row. Yes, they are a part of this bill.
Okay, thank you.
Rep. Knox.
Thank you, Madam Vice Chair. I'm really trying to understand and follow the logic. You read a lot, and I was trying to take notes, and I'm trying to understand your premise. Is your premise on behalf of the victim or access to the victim's family to be contacted, or is it on the attorney side to be able to contact the victim when they don't want to be contacted? That's what I'm trying to understand. What is your premise from what you were reading?
So what I'm reading is a practice that was developed that creates a position that's a liaison between family members and defense teams. It's not to advance the purposes of the defense team. It's to create a communication bridge, because defense teams have information that prosecution do not. They talk to the victim, they talk to the person that committed the crime. They know all kinds of things that victim family members often want to know, but can't get through prosecution. And so what Richard Burr has found, who kind of created this practice back many years ago, is that victim family members actually, when accessing this process, either were able to air all their all the feelings that they had that could be directly communicated through the defense team to the person on death row, which was satisfying to families, or they could gain information that they were not able to have because it's through the prosecution. So they found either that was satisfying and that was fine, or else that would also help them in their own closure process. And so that is what is being offered here in this testimony, is that this is a critical bridge, that while yes, indeed, there are family members, and we've heard from them that don't want access, but there are many family members that actually really do want access and appreciate the access.
I think I understand a little better. And thank you for that clarity. But I go back to what I said originally. It seems like we're complicating something that is so simple and basic. In my simple mind, it seems like we're putting up a bureaucratic process for a victim and how they are to grieve, or how they are to respond, or how they are to communicate with people that they don't want to communicate with. They don't want to be bothered. I understand and appreciate this model that you describe as it relates to the bombing. I think I get it now from your last comments.
I think what this bill creates is not only bureaucracy,
I'm not
but
talking about the bill. I'm talking about what you're proposing.
No, that's what. Okay, all right. This isn't a bureaucracy. This is simple outreach that they can engage in. This creates criminalization.
Rep. Bacala.
I'm sorry, and I've had to step out a couple of times for business, but if we're talking, first of all, a couple things y'all mentioned is, the prosecutor has an opportunity to talk to the family of the victim in that broad definition, but also that prosecutor has the obligation to share any information pertinent to the trial as Brady material, correct?
Mm-hmm.
And this doesn't prevent you guys having contact directly. It only says that if it may require that a coordinator appointed by the prosecuting agency be present. Is that right? Has been requested with the victim service coordinator appointed by the prosecuting agency and the family?
Yes.
So you can talk to them. You just have to do it under supervised conditions. I guess that would kind of how I understand that.
So that would be, that might work in certain circumstances. Ms. LaBeouf can talk about why that's constitutionally problematic.
Well, okay. I'm just trying to put it in perspective. We well established that a suspect has the right to remain silent. Why doesn't a victim have the right to remain silent? We know that if a suspect invokes his right to remain silent, no one can approach him again to ask another question. Why don't we afford the same thing to the victim? So, and again, I will say, we can talk about the prosecution may have access and you don't, but Brady material certainly ensures that whatever the prosecutor uncovers, you should have access to. You also have the right in pretrial hearings to maybe cross-examine if a family member is in fact have information pertinent to the trial. But I kind of go back. I mean, just basic to me, why don't we afford the victims the same right to remain silent and the same right not to be approached and having to invoke that right over and over again? That's just kind of my perspective. And nobody's saying you can't. We're saying if you want to and you really need to, we're going to have somebody there to observe the proceedings, which is the coordinator appointed by the prosecuting agency and the family, I think, if I'm reading that right. Am I just reading it wrong?
No.
No, thank you.
Can I respond to that?
Sure. Yes, ma'am.
Okay. So victim family members absolutely have the right to not speak. That's why they're not being criminalized. So they retain that right. And I want to say that it is the United States Constitution and Louisiana Constitution and statutes require that defense not rely solely upon the prosecution's evidence in defending someone facing any charge, but including the death penalty.
Thank you.
Thank you. Ms. McCreary.
Good morning. My name's Allison McCrary. I'm here as a Louisiana citizen. This bill would criminalize already traumatized families, including families like my own, and would criminalize ministries of faith leaders and pastors like myself. In 1984, I was 2 years old, and me and my mom, we watched my uncle kill my aunt while holding my baby cousin, Morella. Morella was put in the custody of the state at the time. I met my cousin as an adult. She said that she wished that someone had reached out to her so that she could have met her incarcerated dad before he had died in prison. Had this bill been in effect, it would have criminalized someone reaching out to her. In 2009, my cousin Tiffany helped my dad to try to kill my mom and then to take his own life. And at that time, I wanted nothing to do with my cousin Tiffany. She's in prison. Hearts and minds and consciousness shifts and changes over time. Now I visit my cousin, I write her. Our family would have appreciated victim outreach at that time to help heal and to grieve and to process the trauma that we saw. I'm close with my mom and my sisters, and a bill like this would have criminalized anyone who tried to reach out to us. I also believe that if more victim outreach had been possible in the times that my dad was previously incarcerated, if someone had reached out from, as a liaison for the public defender or the district attorney, my dad's death and my mom's attempted death would have been prevented because we would have had services that worked. Since 2005, I've been serving as a volunteer spiritual advisor on Louisiana's death row and visiting the men and the women there. I pray for and with victims' family members. I provide spiritual support and accompaniment to victims' family members. I've facilitated restorative circles between the victim's family member and the person who killed their loved one who's on death row. This bill would incarcerate me for my ministry that I've been doing for almost 20 years in the state of Louisiana as a volunteer. It would also criminalize the 23 other spiritual advisors and pastors that I help coordinate and train and support to do this ministry on death row. House Bill 734 would prevent all of us from offering loving, supportive, and healing ministry and services to people. Including it would tear apart families. One person on death row from North Louisiana, his stepson is considered the victim of the crime, the surviving victim. He's close friends with this guy's daughter. They're the same age. They're about my age, and they're very close siblings. This bill would not allow them to communicate with each other. I'm Facebook friends with the victim's family members. It would keep me from communicating with them and offering support to them in all different ways. I'm also the director of Life, Louisiana Interfaith. Thanks.
Thank you. Rep. Knox.
Thank you, Madam Chair. Now, I want to give Ms. McCurry time to finish her statement.
So as the director of Louisiana Interfaith Against Executions, we are 150 faith leaders across the state of Louisiana. And we meet with victims' family members, and we are against the killing of human beings. And we don't know who we're ministering to at all times. And this statute, this new bill would be so vague that it would keep us from reaching out to pretty much anyone, because it says that anyone who has the interest of anyone on death row. So who has the interest of someone on death row? What does that mean?
Ms. McCurry, I just want to understand your perspective and premise a little further as well, and to make sure I'm understanding the legislation as it's written. Is it your position that as a spiritual advisor that you would be prevented from engaging with the prisoner or with the family member of the prisoners? That's what I want to make sure I understand.
This is with the victim's family members. We're often criticized that we only care about only the person on death row, and that is absolutely not true in any kind of way. That we pray with, we pray for, with very careful intention and doing as much research as possible, we will and do reach out to victims' family members because it is important. It's what we do as ministers. It's what the Gospels call us to do.
I appreciate that, but as I interpret this legislation, and that means nothing, my interpretation, but as I interpret it, it simply indicates that if the victim doesn't want your spiritual advice, then
That's,
they don't want it.
Yeah, but how would a pastor know who they can talk to and not talk to? So if I'm at, wherever I am, if I'm meeting with someone and I find out that they were the victim's family member of someone on death row, I'm in relationship with all 56 people on death row. How do I know who is who? If it's a cousin, the statute is very vague, and it, like for the 150 faith leaders that I work with, how do we know who we're speaking with? And if they are considered a victim's family member or not, and if they meet the qualifications for someone who has an interest in people on death row.
That's an interesting question, and I'll defer to the author when she gets to the table. Thank you.
Rep. Walters.
Thank you, Madam Vice Chair. Pastor McCurry, thank you for bringing your testimony and sharing that with us. And also thank you for accepting your call and operating in the ministry.
Thank you.
Thank you. We don't have any more questions. Thank you for appearing before the committee today. Britton Forsyth, present and would like to speak. Anna, you're going to have to give us that last name, present and would like to speak. If you'll please give your name prior to speaking for the record.
Hey, all. I'm Britton Forsyth. I am just here to read some testimony on behalf of someone that couldn't make it today. To the committee members of the Louisiana House, we are writing to share information relevant to your consideration of House Bill 734. Our parents, Richard and Lynn Ehlenfeld, were murdered along with 5 other innocent, hardworking people. Suddenly, we found ourselves without parents due to senseless violence. Despite all the support we received from our extended family, the community, and the prosecutor's office, there were gaps of information, no real opportunities to ask questions about the defendants or to tell the defense team about our loss, the years of waiting for an arrest to be made, and even longer for the two defendants to go to trial. The attorney for one of the defendants hired a defense victim outreach specialist to work with our family and the other families. This opportunity was important to me and my sisters because we wanted more information and engagement with the legal proceedings than were being offered. We were given the opportunity to express our frustrations and anger about the defense attorney's arguments about their client, the evidence, or anything else we wanted to share. Surprising to us, the DVO specialist simply listened. She didn't defend or justify the defense attorney's actions, and she made us feel like our opinions and our experiences mattered. This is not to say that she was able to change the attorney's actions or behavior, but things did get better. We noticed small changes, and we got more information about certain issues that were important to us than we ever thought possible. It was very important to my family to have a good relationship with the prosecution. They worked tirelessly to help our family achieve a sense of judicial closure. We did not want to lose that relationship, but we felt constrained that somehow we, the daughters who lost our parents, were not freely able to talk with anyone involved in the case that could help us understand the entire case and listen to what was important to us. Rather, we were expected to remain quiet throughout the years of proceedings, take what was given to us, and wait until we were granted permission to speak. By engaging with the defense, we were able to communicate our concerns and get answers to questions we thought were important to us in ways that were respectful and sensitive. Throughout the court process, we never felt that we had to choose sides, something that victims' family members should never have to do. Today, our family continues to work on behalf of crime victims to help them know that their interests matter. We know that every victim has different experiences, needs, and concerns, and that each of them should have access to both the prosecution and the defense. We value the ability to be seen and heard in the court process because we have experienced it ourselves. Yours truly, Dana Sampson and Joy Ehlenfeld.
Thank you. You may.
Thank you. My name is Anna Lelit, and I'm also here to provide testimony from a victim. Hello, my fellow Louisiana lawmakers. My name is Mervyn Guillory, a Louisiana citizen for 59 years, as well as a victim of violent crime. I was robbed and shot in the back more than 25 years ago, leaving me with internal injuries and paralysis, which took 17 years to recover from. The doctors did not think I was going to walk or urinate on my own again. I would like to take an opportunity to express my concerns regarding Louisiana House Bill 734. It is my understanding that House Bill 734 would prohibit any legal representative of an offender from contacting a victim. Right after I was shot and nearly killed, and for many years after, I did not care to know anything about the man who shot me, his legal representative, or that man's family members or friends. All that mattered was that he was behind bars and never to be released. However, over 20 years later, I began to wonder, what is this individual doing? Has he changed his life? If so, how has his life changed? These questions haunted me for years, and I was finally able to meet my perpetrator face-to-face at Angola prison to answer all my questions. This experience was life-changing for me as well as the man who had tried to kill me. A few years later, I was contacted by two attorneys from another state who represented the defendant. The attorneys identified themselves and informed me they were representing that man to gain his freedom. The attorneys were very pleasant. The conversation was extensive and very informative. They explained the entire court and parole process and wanted to know my feelings about the man's release. They and their defense victim outreach specialist followed up with me multiple times to keep me informed about what was happening in court, and they continue to keep in touch with me. Some may well say, well, the district attorney's office could have handled the same situation. Well, I got a lot of information from the defense lawyers that I could not get from the DA, and I was glad that they contacted me. I continue to want information from both the DA's office and the defense lawyers. In short, HB 734 should be denied and allow victims time to process their feelings and thoughts. Time heals many wounds, and some individuals like me may have questions later on in life that they were not ready and or able to confront in the early stage of their case, or maybe even many years later, like me. People don't heal at the same pace. I have appreciated getting information from the defendant's lawyers and the prosecutor, and I don't think that the defendant's lawyers should be prevented from contacting me or other victims. Thank you for your time.
Thank you for reading that testimony. Rep. Knox.
Thank you, Madam Acting Chair. And I appreciate the reading from both of y'all. And as I try to unpack everything that's being said, I'm someone who likes to keep things simple, and I'm someone who likes clarity. And I want to make sure that I have clarity and everyone who's coming to the table have clarity as to this legislation. As I understand it, based on both letters read, if the victims don't have a problem with being contacted, I don't think anything in this legislation prevents that or make it illegal. That's not my understanding or interpretation. And if it's yours, or if it's the reader or the writer of the letter, then please let me know, anyone. But I'm just trying to make sure that there's clarity in what this legislation is saying. My understanding is, based on the letters you wrote, if they want to be contacted, if they want to be engaged, they still have that right. This legislation speaks to those who do not want to be bothered, who do not want to be contacted by anyone. And on that simple premise, I think they should have that right. I'm not trying to complicate something that seems so simple in my mind, and I haven't heard anyone to say otherwise. And so I'm just trying to keep this simple. Is there anything, to your understanding, based on what you wrote, that would prevent that person who wrote the letter from voluntarily wanting to be contacted, as you understand this legislation?
So, Representative Knox, I don't want to speak on behalf of this individual, because I'm here to read in his
I'll
letter.
speak for you.
But
What do you
I
think
can-
now
I
that
can
you
tell
hear
you-
and you have heard the testimony and you see the legislation? I don't know if you've seen the legislation, but as you understand, is there anything from your perspective that would prevent that person from allowing themselves to be contacted?
So what I think he was pointing out in this is that his position changed over time. And what I understand from other people that I've spoken to, other victims, and I myself am a victim of violent crime, and my position has changed over time as well, is that initially, after the crime has happened, I can certainly understand how, right, and I can remember how I did not want to be contacted by the person who harmed me or anybody connected to him, right?
Right.
So I would have readily signed something, even without fully understanding that may block me 20 years later from getting contacted.
And as I wrap up, my understanding and appreciation is that if 20 years later you want to be contacted, that's your prerogative, as I understand this legislation, and I could be totally wrong. If that's still your impression of what this legislation does, then when Arthur gets to the table, we can ask her for that clarity, or she can speak to it. But that's not my understanding as it relates to this legislation that's before us today. If 20 years later you're open to now wanting to be contacted by someone who's sentenced for a crime committed against you, that's your prerogative. There's nothing in this legislation that precludes that, and the amendment even bolsters that ability. So I just want to make sure everybody has clarity. You can have a position, but in that position, then have some clarity as to what the legislation really is indicating.
Thank you, Rep.
That's all
Knox.
I'm suggesting.
Thank you to the witnesses. The board is clear. The cards have been read. Madam Vice Chair. Madam Chair. Sorry. An immediate correction. You have the right to close on your bill.
Thank you, members. Some of the testimony you heard is a desire by the opponents to preserve the ability to hide the ball and bargain with victims' families' grief. There is nothing to stop a convicted defendant from making statements in court at sentencing to give the victims the same closure they spoke of today. We also have a Crime Victim Service Bureau. It manages victim offender dialogue. And last, don't forget, victims have the ability, if they've signed the form, to rescind the form or not sign the form at all. And I find it quite presumptuous to believe that the nature of that testimony, to believe that a victim wouldn't remember that they signed that form. Victims, families, in capital cases, I think we all know, remember everything pretty vividly. Lastly, members, I'll leave you with this. We have seen lawyers representing offenders send formerly incarcerated individuals to victims' homes, trying to persuade them not to oppose parole. We have seen individuals posing as victim assistance coordinators, but actually working for offenders' lawyers and sitting in the parole board's waiting room and eavesdropping on DAs and victims prior to hearings. That is what this legislation is addressed for. And I have spent 4 years in this Capitol, 4 years hearing about criminals' rights and so little about victims' rights. This is just a victim bill. This is for our victims, and they are lost. They have seemed to have been lost in the conversation for 4 years. And I would ask you to pass this bill favorably. Thank you.
Thank you. So there's a motion from the chair that this bill gets reported favorably with amendments. Any objections? There's one objection. Rep. Walters. Madam Secretary, please call the roll.
Representative Villio?
Yes.
Yes. Representative Adams?
Yes.
Yes. Representative Bakla?
Yes.
Yes. Representative Boyer?
Yes.
Yes. Representative Cox?
Yes.
Yes. Representative Fontenot?
Yes.
Yes. Representative Horton? Yes. Representative Knox?
Yes.
Yes. Representative LaFleur?
Yes.
Yes. Representative Moore? Yes. Representative Ventrella? Yes. Representative Walters? No. Representative Wiley? Yes. 12 yeas, 1 nay.
Thank you. This bill will be reported favorably with amendments. Our next